Hello everyone, welcome to my presentation. Content of today's presentation is going to be about section 5016, which contains the grounds that a person may fail the character test. And that part of the Migration Act is guided by Ministerial Direction 110. I don't know if we'll be able to go through too much of Ministerial Direction 110 today, but we'll go through some of the common grounds, the ones that we're more likely to encounter while working with clients. And we'll have a look at a couple of scenarios, so that's what I'm doing. This is what I look like. All right, so these are some of the objectives, as I said. Also identify some common risks and see how character issues are detected and assessed within the department, and have a couple of case examples and common errors. All right, so let's say that you have a client, they have made an inquiry and they may not pass the character test. So perhaps they have a criminal record, or they have had like a run-in with the police, or someone has made like an allegation against them, and they are worried about this, and they raise this with you at the time of a consultation. The first question to ask is, will the department identify and flag them as a character risk? And the second one is there a character ground that the client may not pass? One thing to note is that even if public interest criteria is not a criterion, even if the police checks and that sort of thing is not a part of the Schedule 2 criteria for grant of the visa, the character grounds contained in Section 501 apply nonetheless. So how are they going to detect them? No one's going to know, but they're going to know. So we all know with many visas, client will be required to provide things like police checks for every country that they've lived in for a cumulative period of 12 months. And they use that via asking, questions on the application form and on the Form 80. But there's certain information that the client can provide that will sort of meet that criteria. But the department is very resourceful nonetheless, and they have access to a lot of databases that accumulate information that it's in concert with a lot of different other departments. So for example, one of them is like the Central Movement Alert List. They also have AFP watch lists, prisoner lists from the Department of Justice agencies of each of the states. So one of the biggest things about character is that most of the crimes are governed not by the federal law, but rather the Crimes Acts or the criminal codes of each of the different states and territories. And there's a bit of a mismatch in between them. I'm pretty sure that the department is in concert with the Department of Justice agencies and correctional facilities of each respective state. There's also ABF systems. They also work with Interpol as well. They've got lists to track people, and also open source information or media articles. Recently, so actually the first client that I had when I came to this firm, but this person, he was convicted of an offence a long time ago in the UK. In Northern Ireland. The department had refused him on character grounds before, and then recently we got a notice of intention to consider refusal. And one of the reasons that they cited for the intention to consider refusal is because they found these BBC articles that name him, that say that he was involved in the murder of this young chap. And they are depending on that kind of information to flag him as a character risk. So hence the notice of intention to consider refusal. And I'll keep you updated about that case as we go. Here's an example of the Central Movement Alert List. So this is a FOI document that I just found on Google. If you go quite closely, you can see that they have like the ARC, which is like the alert risk code. So if it's like code 1, code 2, now they are blocked out. So I'm thinking like maybe they're like top secret, like CIA stuff, I don't know. But they're blocked out because of 47E of the Freedom of Information Act. That is, it's information that's too important that it will have like a substantial adverse effect on the efficient conduct of the department. But at number 3, you've got war crimes. So if number 3 is war crimes, how bad must 1 and 2 be, right? And then you've got 4 controversial visitors, like Eminem, and then you've got serious or high profile crime, health concerns, and then they have you see in the second column, they also tell you what the height of the risk is as well. So if is it a high risk, is it a medium risk, that sort of thing. And they've blocked out all the reasons. So annoyingly, all of the things that I want to see are not there. They've been blocked out, but still have a look at the link. It's an interesting document to look at. It has helped me think about what department priorities are and what they consider to be very high risk and very relatively low risk, surprisingly, for like debts to the Commonwealth as well. And like breach of visa conditions is actually considered low risk as well. So yeah, have a look at that. It will give you some good background. All right, let's now go to the ground. So like the first question was, is the department going to identify them as a character risk? Is this person going to be looked at by a case officer, and then is the case officer going to think, maybe I shouldn't give this visa, maybe I should refer to the VACCU or the NOIC, the cancellations section. The next question is, well, if they are a character risk, on what grounds are they not a person of good character? And this is called the character test, which is contained in section 501(6) of the Act. And this is sort of like a mind map of all of the different grounds. I've put some grounds together, like the last circle here, section 501(6) G and H. That's not ASIC, it should say ASIO, sorry. But these ones are kind of like external agencies have identified them as risks. And obviously, I think that they will fall into those high risk sections of CMO, or maybe they're on an Interpol list or an AFP watch list. And for those ones, they're kind of a similar nature. So I've put those together. And section 501B and BA and F are about sort of genocide and slavery and war crimes. So I'm not going to go through those ones in too much detail because they are very novel, but we'll go through some of the other ones. So let's go through this first one. Section 501(6)A, the person has a substantial criminal record. So you've got a criminal record. So what's a substantial criminal record? So a substantial criminal record, you can see here says, if you go to this part of the provisions, then the person's been either sentenced to death or imprisonment for life, or been sentenced to a term of imprisonment of 12 months or more, sentenced to 2 or more terms of imprisonment where the total of those terms is 12 months or more, or they've been, now this one's an interesting one, they've been acquitted of the offence because of unsoundness or of mind or insanity, and they have gone to a facility or an institution for people who have unsoundness of mind or insanity. So that's also one of the grounds. Or the person has been found in a court not be fit to plead in relation to some kind of offence, but they did find that they did commit the offence, and as a result, they have been detained in a facility or institution. So you can't say that like, I was mentally unstable at the time, so please give me a visa. It's even in those situations, the substantial criminal record provision can apply. So some of the keywords here, when you get a matter and you see something like criminal, you see sentenced, then immediately I think of 501(6)A, and then I look at like, okay, how long were they there? If I see like death, imprisonment, detained, unsound, not fit to plead, these are the words that I guess will automatically send your alerts to this part of the Act. Okay, so now that we know this, let's go through some of these questions. It's almost like a quiz. So what if I was convicted of 2 counts of assault? So I hit somebody and it's 2 counts, 2 hits, and each one attracted a penalty of 6 months in prison. Do I fail this test because I meet the definition of substantial criminal record? Yes, Josh said yes. It can be yes. It can be yes, yeah, if it's a consecutive terms and altogether it's 12 months. But if it's like 2 months here, 3 months here, and they're separate occasions, then it's not really considered 2 or more terms of imprisonment where the total of those terms is 12 months or more. Like, it's not that cumulative period. What about weekend detention? So it turns out that some of the jails are so full that these people, they get convicted of some kind of offense and they only need to go to the corrective facility on the weekends, and they're allowed to work from Monday to like Thursday, and then they have to go to the correctional facility and spend the weekend there. Like that is the arrangement. So yeah, what about in those cases? What if I needed to be in custody for 3 days a week for the next 12 months? Is that a substantial criminal record? Have I been sentenced for 12 months? What do you reckon? It's not 12 months. Yeah. It's, strictly speaking, it's 3 times 52, which is not going to be 365 days. So when they say the next 12 months, they really mean 12 months. What about if I receive a suspended sentence? So a suspended sentence, right? Does anyone know what a suspended sentence is? It means that like, oh yeah, you got 12 months, but you don't actually need to spend the 12 months in like, you don't need to actually spend the 12 months in the correctional facility because you're on a good behavior bond. You were nice to everybody, and yeah, for the next 6 months, you don't have to be there. Your 12-month sentence has been suspended. So is that still sentenced to a term of imprisonment for 12 months? How about Sylvia?
I reckon it still be considered as a term of imprisonment for 12 months.
Yeah, that's exactly it. Yeah, suspended just means that like that you were nice and they're letting you out, but the sentence still remains 12 months. So yeah, it doesn't mean anything really. It's still a substantial criminal record. Hey, what's the next one? Okay, I got a spent conviction that would have been a substantial criminal record from ages ago. So I'm clear now, right? I'm sure there must be people that are coming up to that will come up to you in your entire career of being and in my career being a migration lawyer, where people have spent convictions from maybe 20, 30 years ago, and they're going like, oh, but it's spent. But will they fail this part of the character test? Okay, so actually, a spent conviction is just one that doesn't turn up on some police certificates. This is important because a lot of UK people get the UK police certificate that doesn't have the spent convictions on there. I believe that in all my life of dealing with UK clients, a lot of them get this police certificate, and later on we get a request for more information asking for a new UK police certificate that includes all spent convictions as well. So the department's doing this on purpose because they want to see this, whether or not they have a substantial criminal record or not, or any other kind of criminal record, no matter how long ago it was. A spent conviction is one that doesn't turn up on some police certificates, like a nationally coordinated criminal check, because it's minor or it's outdated, and like in certain contexts, you don't need to tell some employers about these kinds of spent convictions. I'll tell you a story. My sister, she works at Hayes. And Hayes is like a working recruitment company. And employers come to Hayes being like, we need like 150 workers. And then Hayes will like go out and find those 150 workers, and then they'll do the paperwork in between. So they're a brokerage company. The employer often asks Hayes, can you do the police checks, or can you do the police checks for them and make sure that they don't have any like heinous crimes or like substantial criminal records. With Hayes, they will have an assessor come in, do like I don't think it's an AFP, I really think it's just one of those nationally coordinated criminal checks. And then the employer might ask them, oh, can you tell me what's on their record? The assessor, especially for spent convictions, they will not tell the employer what the spent conviction is. They'll just be like, they have some spent convictions, but none that are relevant to the position. And that's it. That's the best that the employer can get. And if the employer really, really wants to know what those convictions are, then they'll have to ask the individual themselves. And usually the individual will say no. So yeah. Now, interestingly, the reason why the department can ask for these spent convictions is because of Section 85 ZZHD of the Crimes Act. Decision makers dealing with the Migration Act are specifically exempted from the restrictions on taking spent convictions into account. So they have a special license to ask for spent convictions, and if the spent conviction shows that there was a sentence or an imprisonment of 12 months or more, then the department will consider that they fail Section 5016A of the character test. Okay, these last two ones I'll just do myself. So I got a police caution because I was being annoying at a club. Am I done for? Okay, so police cautions, not under this provision you wouldn't be. A caution isn't really considered a substantial criminal record because it doesn't fall under any of those definitions. But do think though that they could fall under some of the other character test grounds as well. And I have an AVO or an ADVO against me because I punched my partner. Is this a criminal conviction? I'll explain, I think we all the answer to this question. The AVO itself is not a criminal conviction. But I don't think that, I think it's obvious, but I don't know why I didn't really understand why an AVO is not a criminal conviction, even though it is a police person who administers the AVO. The standard of proof is the reason why an AVO is not a criminal conviction. For someone to be convicted of a crime and to have a criminal record, the standard of proof is going to be beyond reasonable doubt. You have to go to trial and they have to make a finding of fact that shows that this person committed the crime, but beyond reasonable doubt. Everyone in the jury has to say, yep, he did it. Yep. But for an AVO, a police will just take two statements and they could have lied the hell out of those statements. We don't know. The police doesn't know yet because they haven't gone into any investigation. And they just put the AVO there provisionally to say, look, it looks like you guys are going to hurt each other. So I'm just going to keep you guys apart. But if you break this order, then that is going to be a criminal thing. Like things are going to get very, very nasty from there. So an AVO is not a substantial criminal record, but it could fall under one of the other grounds. So what other grounds? Let's have a look at the other grounds. What other grounds do you reckon the AVO might fall under? Because this is a very common one that comes up. Anybody want to hazard a guess? 60. Risks that future conduct would be criminal or harmful to Australian community. Yeah, that's a good one. Yeah, because a lot of AVOs, they are taken out to keep abusive people away. They're protective orders. So if someone's been stalking me or someone's been abusing me or something like that, then I would go to the police and tell them, can you, give me a piece of paper to keep this person away? This is the ground. Risk that future conduct would be criminal or harmful to Australian community. An AVO might actually point to another ground like this 6D2. This person may harass, molest, intimidate, or stalk another person in Australia. So, although it's not a substantial criminal record, it may fall under this category. Now, the Ministerial Direction 110 says the assessment for future conduct in terms of how am I supposed to know whether there is a risk or not? It says it must be more than a minimal or remote chance, right? It can't, so more than a minimal or remote chance. So that's what the assessment is. There doesn't need to be actual signs of violence. Just threat damage to property can also suffice in relation to harassment or harm to Australian community. This is a fun fact, but public rallies or even extreme views could suffice, even if it's not like a matter that has been prosecuted by the police or anything like that. A long time ago, this is something that Vincent found out when he was helping me, but the previous used to say 60 that there is a significant risk that the person would engage in criminal conduct in Australia. Currently, significant has been deleted, so just risk is enough. So there we go. So we'll look at the next ground. This one is if a member of an organization is involved in criminal conduct. Sorry, I think that the screenshot of the actual provision is gone here, but if the department suspects that a person is a member of an organization that is involved in criminal conduct, then they may fail this part of the character test. The Ministerial Direction says that reasonable suspicion does not have to equate to actual belief. So the person who is making this assessment, they don't have to be fully certain, or they don't have to believe in their heart that, this person is part of a terrorist organization or like a criminal ring or like a drug ring or a gang or something like that. But it needs to still be more than just like, they got a tattoo. They must be part of a gang. Like, it can't be that, right? So for the suspicion to be reasonable, right, it should be a suspicion that a reasonable person could hold in the particular circumstances and based on objective consideration of relevant material. So they need to find some kind of material that where any objective person would think that this person does have this association with a criminal group. And one of these examples here is the case of Dr. Mohammed Hanif. I'm not sure if you guys are familiar with this case. I think it was quite famous back in the day, like around 8 years ago or 6 years ago. But the facts are he was holding a subclass 457 visa. And then he got and it was because he had provided SIM cards to his cousins who are suspects of a terror attack. And he had been charged before, but the charge was dropped. Was the association giving rise to failure of the character test? The judgment was that association should be interpreted narrowly, where fundamental rights are at risk. So have a look at this one. It's very interesting. There's a lot of other issues that they look at, but they do discuss what does it mean to be associated. Is the act of giving those SIM cards an association, or like how involved do you have to be in order to be associated with a criminal? This is also another one. It's a long case. There's a lot of facts, but essentially this visa got cancelled because they're suspected to have been a member of a motorcycle gang. And the ratio is that if the minister wants to, this was another issue where they were like, if we cancel the visa, what happens to this person? Like what about their rights? But that's a discussion for another day. Yeah, just have a read of it. I want to speak more about it, but I feel like we're going to get too far away from the cancellation on character. Whereas this case is more a story of, well, isn't it unfair to cancel this guy's visa if he doesn't have anywhere? And isn't he being punished twice if his visa is cancelled when he's already served time? This is an interesting one that I just wanted to... It's about escape from immigration detention. A person will fail this ground of the character if they have been convicted of an offence that was committed during an escape by the person from immigration detention, or after the person escaped from immigration detention but before they were taken into immigration detention again, or they've been convicted of an offence against section 197A. And 197A is about, like, you know, you just shouldn't escape from immigration detention. That's it. So if you escape immigration detention, or if you commit while you were on then this is going to be a red flag. I don't know how much you guys know about immigration detention, but I had a look at what it means to be in immigration detention, and there's different... What if there's a kind of immigration detention where the minister makes a determination and you are actually under house? What about that kind of immigration detention? Is that... and you commit a crime, like during... Would you fail the character test on the... Okay, so the minister... they can make a residence determination where, like, they effectively put this person under house arrest, right? If it's in the public interest to, it does count as immigration detention. So while they are in immigration detention and they go out and they are convicted of an offence, it doesn't matter how small the offence is. I don't know if I can ever say so, but if they commit an offence while they are in immigration detention or while they have escaped immigration detention, then this is going to be, we have to be aware. Speaking of immigration detention, the next question that I had was, well, what about Nauru then, which is an offshore processing centre? What if I escape from, I manage to lodge another visa and I might get this visa like refused or cancelled? Will I fail? Yeah, answer's no. Josh is right. So Nauru is actually not considered immigration detention yet, because it's actually an offshore regional processing center, or ORC. Any conduct that's committed in an offshore processing center is considered on other character test grounds. Yeah, the offshore country is like, it's a delegated exercise of power via 198AB. And Nauru has its own domestic, and they will be answerable to that law as well. And the processes get litigated in the Supreme Court. So yeah, this is just a fun fact. All right, okay. Oh, this one. So genocide, slavery, war crimes. Okay, so the minister reasonably suspects that a person has been or is involved in conduct constituting of one or more of the following. People trafficking, genocide, crimes against humanity. These are the are sort of, they're not even just domestic crimes. These are crimes where like an international, it's of serious international. In this case, it's not really a migration case, but what happened was that ASIO had information about this. I honestly, I don't know what it was. I'm pretty sure it was people smuggling. It was found that, the minister can rely on that. So, the department can use information to make a determination on whether they meet the character test or not, whether they pass. This one, this about 501, past and present criminal or general conduct. This is very confusing. Okay, it means that this person has done some kind of conduct, but it could be criminal. So does that mean that like I'm just a bad person and the department just doesn't like me, so they can't give me a visa? Like that's what it sounded like to me at first. But it turns out to be sort of like this, right? This is how I see the department's thinking process. Number one, does the person have the ability to make sound moral judgments in their day-to-day? So for this reason, the concepts of criminal conduct and general conduct are not mutually exclusive. So just because something is criminal and you've got criminal conduct and you've got general conduct, they don't cancel each other out. And if no, right, if it doesn't look like they're able to make good decisions generally, and it looks like they're about to hurt someone because of because of evidence of their criminal conduct and general conduct in what are all of the circumstances that might indicate this? Because the department has to have a good reason for why they're going to refuse this visa or cancel it. But let's put this into like a case sort of study thing. Let's say that I'm not a substantial criminal, so I don't fall under the first character test of the 12 months imprisonment or imprisonment for life or being death. But I've done some shameful things in that, maybe some larceny and maybe some fraud, but I got a good behavior bond and it's not to the level of substantial. What am I supposed to do? Do I tell the department that, yes, I did these things, but I'm still a person of good character? Or does the you are a person of bad character, or you are not a person of good character? Which one comes first? I can't hear you, sorry. We need a proof first? Yeah, good. Yeah, it's good to come clean. I guess even though the law, sorry for the wall of text, right? But if the IMI account asks us, have you been convicted of any crime and stuff? It's true that we should say yes for now, right? Because it's not good to lie. You don't want to intentionally mislead the department, because that would be that would trigger this, and I think that were 2-0. Even though the law says that the person has to satisfy the minister, I have to satisfy the minister that I pass character test. It's actually the department that bears the burden of proof to say that, look at all these grounds, 1, 2, 3, 4, 5, all these A to H, and you don't meet this one. It's actually them that have to show that there is a ground and show the reasons for why they think that your client, so like they can't just say, oh, generally I don't like this person, and that's what it sounds like sometimes when you look at this particular ground. This particular ground has so much case law, but the sort of the prevailing answer is that the minister is the one who has to explain why they don't pass that character test or why they don't pass that ground. So if we have a landmark cases like Godley, right? It says Section 5016C requires the minister to have regard to the visa applicant's past and present criminal conduct and or past and present general conduct, and then determine as a fact whether that person is not of good character. Unless such a finding of fact is made by the minister, the visa applicant passes a character test. So if you couldn't find the fact that says that, oh look, they don't pass the test, then That means that how many bad vibes the person is giving, the minister doesn't have a reason to refuse the visa. So if the minister finds that the visa applicant is not of good character and that person does not pass, that's when the minister can refuse based on, Section 501. And this was echoed again in Mujahdinovsky. So just read, sort of like a elaboration of godly. So yeah, read it in your own time. But it's a very good how a person can So we've reached the end of the presentation. I will end on a moral or ethical note. Many people think that when we are helping people that have character concerns and like legit they did the bad thing and like they've been like convicted and all of that and they still are trying, people think that, this person doesn't deserve a visa or like we shouldn't help. The famous philosopher Mencius said, "How could the arrow maker be any less humane than the armor? The arrow maker is concerned solely with injuring others, while the armor maker is solely concerned that others might be harmed. Likewise, a shaman who prays for healing and an artisan that makes coffins and outer caskets are also of this kind. So just practice humaneness and let that be your motivation. It doesn't have to come from others." So he's saying that to the ethical, helping people in these kinds of matters, they're merely trying to find the best way to navigate their current circumstances, right? And the department's doing their job, and we're just doing ours. That's it.